Welcome to Resilience and Resolve with Lance Drury.
Welcome to Resilience and Resolve. I'm Evan Mack with tax attorney Lance Drury. Today we're discussing the legal risks of misclassifying workers as independent contractors and why businesses and freelancers need to understand IRS rules before it's too late. Lance, welcome back, sir.
Good to see you again, Evan.
Good to see you. Good to be seen. Good to be seen. Right off the bat, what's the legal difference between an employee and an independent contractor?
Well, an employee is classified as an individual whose work is controlled by the owner in terms of hours, in terms of the equipment, in terms of the projects that are done. An independent contractor basically sets his own hours, has his own equipment, things of that nature. So the major difference, and there's probably like 13 to 15 different ways that courts take this into consideration. There's 13 to 15 factors, something like that. And it mainly boils down to the amount of control that the employer has over the employee's work. And what you find a lot, and we've never had a worker reclassification case. I represent over 1,000 clients at any one time. I'm kind of surprised. But what happens is just because you call them an independent contractor doesn't mean in actuality they're an independent contractor. If you exercise all this control, you're not really an independent contractor. You have an employee and you're in danger of having the IRS come after you and reclassifying your employees and then having you pay for back payroll taxes. Because the reason owners do that is they don't have to mess with the taxes. Then it's up to the employee to pay those taxes in if they're a 1099 individual.
So why do you think the IRS is so focused on worker classification?
Well, I think it's because they're losing monies on those back payroll taxes and they want to go after the deep pockets. So that's why they go after the employers, is because they are the ones that have more money than the individual workers. And so they're going after those entities so they can bring in more money into their coffers. I think that's the primary reason. Plus, they don't think it's fair that, some people just classify them as independent contractors when they're really not independent contractors.
That makes sense. Do you know about the criteria or any tests that the IRS uses to determine a misclassification?
Well, like I said earlier, it's basically how much control does the employer exert over the employee's work. So, if you control the place of work, if you provide all the equipment, if you tell them, here are the hours that you have to work, and there's various other factors, then it's more likely or not that a court's going to find that you exercise enough control that the employee should be reclassified as an employee and not classified as an independent contractor. So it basically comes down to how much control does the employer exert over the employee's work.
So Lance, what are the penalties, though, for misclassifying workers?
Well, that's a good question. I really don't know the answer to that. I'm sure that there might be some fraud penalties. I'm not sure. But again, if there's going to be a reclassification and they go back to, back payroll taxes that are due for prior years, obviously you're going to have failure to pay penalties and you're also going to have interest that accumulates. So at a minimum, you're going to have to deal with that. And that could be several years. And it doesn't take much to get to six figures in payroll cases. It's hard for personal tax liability, but not for payroll tax. You see a lot of these firms that incur six figures in terms of back payroll taxes just because of the number of employees that they have.
So you think that's just because these penalties can happen maybe because of lack of maybe monitoring it or maybe because the number of employees that somebody has?
I just don't think they don't want to bother with the payroll tax and all that. They just want to, okay, here's what you get. I just got to write out one check and I'm done with it. We don't have to worry about sending in monies on a quarterly basis or a monthly basis for payroll taxes. We can get rid of all that work just by putting that responsibility on the employee. So I think it's basically they're just trying to get out of more work.
But what about the workers in general? Like, can the workers themselves face problems from being incorrectly classified?
Normally, it's not the workers. They're going after the the employers for that. Now, obviously, if the employees aren't paying their share of the taxes when they get their 1099, then there could be problems for the employees as well. But normally, when the IRS does this reclassification, they're going after the employers. They're not going after the employees.
How can a business fix a past classification mistake, though, Lance?
Well, they need to go back and they need to amend, how their payments are done. They need to go back and rectify the problem and make sure that they have W-2 employees. And I think that would save them any problems, but I don't know how many of them really do that. But, if you have a number of years where you've been misclassifying your employees as independent contractors, I think you can go back, file a W-2 in lieu of the 1099, and that'll take care of the problem for you.
Any limit on the years you can go back, or is there a cutoff?
Not that I'm aware of. Like I said, I've never had to deal with these cases before. There probably are limitations, if not a formal limitation. There's limitations simply because of the manpower in the IRS. I don't think they're going to go back 10 years on a case. It's sort of like, it's sort of like filing tax returns. The IRS only requires that the last 6 years' tax returns be prepared and filed in order to be compliant and in order for an individual or a business to get a resolution with the IRS. And so particularly with self-employed people, and this is a huge mistake that accountants make, they'll require their client to go fill out and file all of their back tax returns. Well, that's a problem because you're putting tens of thousands of liability on the books for your clients when you don't have to. And because of the lack of manpower at the IRS, they're not going to go back at this late date and file a 2016, 2017, 2018 tax return for their individuals and businesses. They don't have the time to do that. They don't have enough employees to handle that.
Are the IRS programs that reduce penalties if a business comes forward? Any programs like that?
There might be, but I've just not had any experience in that area. And so I can't tell you. I'm sure that if they go ahead and voluntarily do this on their own prior to the time that the IRS comes in and comes after them, that they're probably going to be okay with the IRS.
Out of all the, the clients you have, you said over 1,000, why do you think you haven't encountered this? You think, is it not a common problem, or is it just something that just hasn't happened in all the people that you represented?
Well, that's a great question. I don't know why you would think at some point, because we probably represented 10 to 15,000 clients over the years, and the IRS had expended a lot of funds years ago going through this worker reclassification program. So I can't really tell you why that hasn't happened. Maybe they're not targeting in the areas in which I represent people. I just don't know. But it's really surprising to me that we've never been confronted with that problem. And I don't think it's ever been raised in any initial consultation that I've had with people.
Wow. So what makes a company more likely to get audited for the issue?
I really don't know what the criteria is. My guess is maybe somebody blew the whistle on them. Like their own employees, or their own employees could complain and said, hey, I don't know why I'm doing this. I don't know why they're putting the burden on me to pay the taxes. He should have been taking this out all these years. Maybe it's done randomly. I know certain audits are done randomly. So, it may just be a random thing as well. So I can't really tell you, but I would think the most likely situation would be where one of their workers blows the whistle on them to the IRS, and that's why they get investigated.
So when should a business consult a tax attorney like a Lance Drury about contractor relationships?
Well, I would do it right away. I mean, I can tell you this, I have had conversations during initial consults with business owners where they said that their employees were independent contractors, and I would probe with questions, and I said, you better watch out. You better stop doing this because of the amount of control that you exert over that worker. They're liable. The IRS is liable to come in and reclassify these individuals as employees rather than independent contractors, and you're going to be in big trouble. So you need to go back and rectify this problem before it becomes serious. We have had those discussions with people.
Lance Drury, as always, sir, thank you for the information. Thank you for the insight.
Thank you, Evan. Always a pleasure to see you.
And thank you guys all for watching. Worker classification errors can cost thousands in penalties. Visit lancedrurylaw.com for help getting it right before the IRS steps in. Thank you so much for joining us.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.